Welcome to my channel Swarna Legal Academy. Here you will get law related tutorials and it will helpful for your all law exams like clerk exam and judicial exam and LLB semester exams. Okay, so today we will go to start one new topic, Indian Evidence Act 1872. If you really like this video, please subscribe it and please share to your friends. Okay, so let's start now. Indian Evidence Act 1872. Introduction. It is expedient to consolidate, define and amend the law of evidence. So first, it is expedient to consolidate, define and amend the law of evidence act. It will come in exam. It is expedient to define and amend the law of evidence. Then you students have to write, they'll consolidate. Okay, so it is coming in exam also. It is expedient to consolidate, define and amend the law of evidence act. Law of evidence. It is a procedural law and lex fori. Lex fori means Indian Evidence Act. It is applicable to the all courts and it is applicable to the civil procedure, also to the criminal procedure code. It is lex fori because it is applied in all Indian all courts. It is a subject of concurrent list. Concurrent list, it is related to the constitution. In constitution, 3 lists are coming. Out of them, concurrent list is there. So, Indian Evidence Act is a subject of concurrent list. Indian Evidence Act enacted on 15th March 1872. When it enacted? It is enacted on 15th March 1872 and it came into force on 1st September 1872. So if in exam the question will come when Indian Evidence Act enacted, so that time you have to write 15th March 1872, but when it will come the question when it came into force, that time you have to write 1st September 1872. So these two dates you have to remember. One is enacted on 15th March 1872 and came into force on 1st September 1872. Now James Stephen is the father of Indian Evidence Act. Indian Evidence Act was drafted by James Stephen. So he is the father of Indian Evidence Act. Who is the father of Indian Evidence Act? James Stephen is the father of Indian Evidence Act. It contains 11 chapters and 167 sections. The Indian Evidence Act contains 11 chapters and total 167 sections. Okay. Now we will go to interpretation clause. It is coming under section 3. Some of the clause here mentioned and we will write. We will start now. One is court. What do you mean by court? Court, what it defines court? Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. So court includes all judges and magistrates and who are authorized by the government for the court, but not the except arbitrators. Arbitrators are not included in court. Court includes all judges and magistrates and all the persons who are legally authorized to take the evidence by the government, but not the arbitrators. Except arbitrator, all are included in court. All judges, magistrates and legally authorized to take the evidence appointed by the government of India. Okay. So arbitrators are not included in court. Now we will go to fact. Fact means and includes. What it defines fact means what? Facts means and includes anything, state of thing or relation of things capable of being perceived by the senses. Fact means anything, state of thing or relation of thing capable of perceived by the senses. Illustration, that there are certain objects arranged in a certain order in a certain place is a fact. Fact means that certain objects arranged in a certain place is a fact. Suppose there is a table, there is a bed, there is a fan. So that all are objects arranged in a certain order in a place, that is known as fact. That man heard or saw something is a fact. It is related to sense. Heard means we heard something. we saw something. So it is perceived by senses. Our senses perceived by this heard or saw. We saw by eyes. We heard by our ears. These are coming in senses. So anything being perceived by the senses, that is also a fact. Suppose we saw something, that is a fact. We heard something, that is also a fact. That man said certain words is a fact. That is also a fact. Suppose somebody said something, that is also a fact. Any mental condition of which any person is conscious. Any second is the fact it comes anything, state of thing or relation of things capable of being perceived by the senses first. Then after it coming second point, any mental condition of which any person is conscious. Illustration, that men hold certain opinion. Suppose we hold certain opinion. We know something about somebody. That is also a fact. Has certain intention. Such a certain intention, act in good faith or fraudulently, uses a particular word in a particular sense. What any mental condition, it may be a good faith or a fraudulent or mensary also it is coming under this. So any mental condition of which any person is conscious, that is coming under fact. Uses a particular word in a particular sense. So we use different words. It is related to our mental condition, like good faith, fraudulently, mens rea, that we are using in particular word in particular sense. So we will in different fact, in different time we are using that words. That man has certain reputation is a fact. Also that is a good reputation, bad reputation, he is a good person, that all are reputation also coming under fact. So fact means and includes anything, state of thing or relation of things capable of being perceived by the senses. And the second point is any mental condition of which any person is conscious. Okay, so it's over. Now we'll go to next point, which is relevant. Relevant. One fact is said to be relevant to another when the one is connected with the other in any other ways referred to in the provisions of this act relating to the relevancy of facts. Section 5 to 55, these all sections coming under relevant. Okay. So Indian Evidence Act, the sections 5 to 55 coming under relevant. One fact is said to be relevant to another when one is connected with the other in any other ways. So there are two facts. One fact, if related to another fact, then that is relevant. Any other way referred to in the provisions of this act. So in different provisions 5 to 55, section 5 to section 55, different provisions are relating to relevancy of facts. Illustration, suppose A killed B by a gunshot. Suppose A killed B by a gunshot. B has, so here the relevant facts what will come. B has purchased the gun from a shop is a relevant fact. So B has purchased the gun from a shop. It is a relevant fact. The bullet got from B by police is matching with the gun. Another relevant fact is what? The bullet it got by the police from the body of B also matching with the gun. So that is also a relevant fact. People saw A with the gun near the spot. So people saw A near the spot with the gun. That is also a relevant fact. So these all are relevant facts is connected to the death of the person B. Suppose A killed B by a gunshot. So that time this all happens. B purchased the gun from a shop. Relevant fact. B, the bullet got from B by police is matching with the gun. That is also a relevant fact. People saw A with the gun near the spot. These all are relevant facts. So one fact is said to be relevant to another when one is connected with the other. So these all facts are connected with the one fact, that A killed B. So these all are relevant facts. Now we will go to fact in issue. The expression fact in issue means and includes any fact from which either by itself or in connection with other facts the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. Okay, fact in issue means, the expression fact in issue means and includes any fact from either itself or in connection with other facts. The existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. So this is the definition of fact in issue. So one illustration you will come what is fact in issue in this illustration. A accused of murder of B. Okay, A is the accused of murder of B. At his trial, the following facts may be in issue. So how the fact in issue? The following facts: that A caused B's death, that A intended to cause B's death. So before A has intended to cause B's death, so this is the fact in issue, that he has intention to cause B's death. That is a fact in issue. It includes any fact from either by itself or in connection with other facts. Okay, now it related to the other facts. A intended to cause B's death, existence, non-existence, nature, extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. That A caused B's death, that A intended to cause B's death, that is a fact in issue. That A had received grave and sudden provocation from B. So here also one more fact in issue. A had received a grave and sudden provocation from B. So A caused B's death. Okay, A caused murder of B because B gave sudden provocation to A. That he told something which is not liked by the A. So due to that sudden grave and sudden provocation, A killed B. A caused the accused of murder B. That A at the time of doing the act which caused B's death was by reason of unsoundness of mind incapable of knowing its nature. So that A at the time of doing the act which caused B's death was by reason of unsoundness of mind incapable of knowing its nature. Also, it may be a fact in issue that at that time, while A accused of murder B, while A killed B, that time B was unsoundness of mind, so that he was incapable to know the nature of its acts, that he was unable to know his nature, so he caused the death. So this is also fact in issue. The expression fact in issue means and includes any fact from which either by itself or in connection with other facts. So these all facts are related: existence, non-existence, nature and extent of any rights, liability asserted or denied in any suit proceeding necessarily follows. So this is the illustration which explains fact in issue. A cause of murder of B. At his trial, the following facts may be in issue. So while in trial, the prosecution collected all the fact in issue. That A caused B's death, that A intended to cause B's death, that is a fact in issue. That A had received grave and sudden provocation from B, that is also a fact in issue. That A at the time of doing the act which caused B's death was by reason of unsoundness of mind, because he don't know the nature of the act, because he was a unsoundness of mind. So for that reason he may kill B. So these all are the fact in issue. So this is over. Thanks for watching. Bye bye. Next time